Hi everyone, my name is Ben Cody. I'm an attorney in Massachusetts with Cody Law Group, and today I wanted to make a slightly different video than what I normally make and kind of go through a recent case that I've been working on. So I handle evictions on behalf of landlords on certain occasions. It's not really an area that I focus a lot of attention on in terms of marketing, networking, but it is a service that I offer primarily because when you work with commercial real estate, you need to understand how evictions work, because that's a lot of what your clients end up having to do if a tenancy doesn't work out well with one of their tenants. So I thought it would be helpful to go through one of the evictions that I recently handled in the district court to give you an idea of what an eviction looks like in 2025 in Massachusetts and give you kind of an idea of what the cost would be. In our particular case, this was resolved last week. We had a summary process trial on the 3rd. And in our particular case, we actually had a really good outcome. So my client has been paid most of the money that was outstanding, and if the tenant doesn't pay within a few days, so actually by today, there's an agreement in place that says that the execution would issue immediately on 3 days' notice. There's attorney's fees to be paid, and in this particular case, the move-out won't be overly expensive. But I think this is a good case to examine how evictions work, and then ultimately what that will allow you to do is really factor in, okay, if I have an eviction in one of my units in one of my investment properties, what does that look like as part of my business? How is that going to affect the bottom line? Am I set up in a place where I have enough carrying costs in reserve to cover how long this really can take? And if things had gone much different in this case, if we hadn't been paid, if there wasn't this agreement towards the end, which the judge skillfully suggested the parties take, or make, I should say, if that wasn't the case, how would this work in your rental business? So looking at the overall structure of what I want to cover today, we have the basics of an eviction. I want to go through some of the facts of a recent case that I was working on, the one from last week, the timeline of this eviction, because I think this is important to see, the challenges that came from this, what the outcome was, and what we can learn about it, both as landlords, but business owners in general. If you own real estate and you're renting it, it's a business, and you need to understand the costs that go into your business. So evictions in Massachusetts, they follow a summary process eviction procedure. And it's kind of a running joke that summary process is supposed to mean that it's summary, that it's quick. But in recent years, it's really been anything but that. And it's for a few different reasons, which we'll get into a little bit later. But there are fundamentally 3 different types of evictions. So there's fault-based evictions. So that would be if you violated a term of a written lease. So let's say the lease says you won't disturb the use of enjoyment of the property by other tenants of the building, and then you're having all-night parties every day of the week. There's loud noises with supporting police reports. That could give rise to a fault-based eviction where you're violating a term of the lease. Therefore, that entitles the landlord to terminate your tenancy and evict you. There's no fault evictions. That's actually what we have in this case, and that's when there's a tenancy at will, or a month-to-month tenant, sometimes it's called, and they are essentially being evicted not because they did anything wrong, but because the landlord has the right to take their property back. Maybe they want to renovate the property, maybe they want to rent it to somebody else, maybe they want to live there, maybe they're trying to sell the property. Whatever the case is, the landlord has the right to recover the property. And then there's also our non-payment cases. So I would say probably non-payment is the biggest in terms of absolute number. So non-payment would be you don't make a rent payment when due within the grace period defined in the lease agreement, and then the landlord is able to terminate your tenancy. There are some specific rules we're not going to get into with curing that default, but it's probably the most common type of eviction that we see in Massachusetts. So the recent eviction that I handled was a tenancy at will, so there was no written lease, and the tenancy renewed each month on the first day of the month for another month period. And this is not a type of tenancy that I would recommend having. I'd recommend having a written lease, even if it is month to month. I think it's important to have the ground rules explicitly defined in that written agreement. It certainly would have given us a lot more leverage if there were attorney's fees provisions and some other things that we like to see in a written lease. In this case, it was no fault, so we're not alleging that there was a violation of the lease. We're not alleging that there was any drug activity at the property. We're not saying that he failed to pay payments when due, and ultimately the reason that the landlord wanted the property back, which landlord doesn't have to tell the court why, but our reason was that the landlord wanted to renovate the unit and then rent to a long-term tenant, because there's more money involved in that. If the property is nicer and we're able to tie this up for a longer period, it actually improves the value of the property with that cash flow that's coming in. So in our particular case, the tenancy was created in March of 2024, and so that was on a handshake. And there's a whole backstory about why this was created. There were some health issues. The parties somewhat knew each other through the tenant's brother. I'm not going to get into too many identifying details just for confidentiality purposes. But you can see that in March, the tenancy was created. The reason for the tenancy was over in August, and the landlord, after being told that the tenant wouldn't move out, asked me to send a notice to quit. So in Massachusetts, for a no-fault eviction on a tenancy at will or a month-to-month tenancy, you have to give a 30-day notice to quit. So that was served on on August 20th. But that isn't 30 days from the date of the notice. It's actually 30 days from the next rental period start date, which was September 1st, because the rent was due customarily and by the actions of the parties on the first day of each month, which means that we had to serve the month before. The tenant has the entire month of September to find a new apartment and vacate. And ultimately, the tenant failed to vacate the property on the 30th. So on October 4th, just a few days later, we served a summary process summons and complaint, which is essentially just telling the tenant that the landlord is starting an eviction lawsuit in our case, the district court. So in Massachusetts, you have a few different courts you can choose from. Usually we're looking at the housing court for residential tenancies, and then the district court for residential and commercial tenancies. In this case, we picked the district court. There is a little bit of a risk with doing that based on timing. But in this case, we felt that it was necessary because we liked the way that the district court in Plymouth handles eviction cases. October 15th, the summons was filed. So I'll show you the summons and complaint in a couple minutes. But basically, we served within the timeline or the time frame that the statute requires. And you'll notice that there was actually a huge delay. So from October 15th until December 18th, we didn't have any action happening besides just receiving notice that there was going to be a hearing for a status conference. A status conference basically is just a meeting at the court that now is required after COVID. So before COVID, we would actually have the trial date scheduled, and it would be scheduled based on the number of days after the summary processing summons and complaint was filed. So you might have it filed on the 15th, and then 3 weeks later we have our trial scheduled. And very often the trial might be delayed, whether the tenant asks for discovery, maybe they filed counterclaims, maybe there's a motion for continuance, maybe there's some other reason why the trial can't go forward that day, but generally it was a lot tighter. Now we're looking at the whole month from October 15th to November 15th, and then November 15th to December 18th. So we're looking at over 2 months between that initial filing and the status conference, which isn't even the date that we get any relief. So once we met at the status conference, we tried to negotiate with the tenant, and that was almost successful. The parties almost came to an agreement, but there we really couldn't get to that last little bit. Generally, I like settlements. They tend to be a lot less expensive for the landlord. Everyone knows what they're getting, because whenever you leave it up to the court decides, and you might not be happy with the result. And then, luckily, we had a 2-week period between the status conference and the trial. So January 3rd, 2025 is when we actually see the trial scheduled. But you'll notice that I also drafted and filed a motion to amend the account. So with the initial summons and complaint, the tenant was actually current, and then we went back after the tenant stopped making payments. When the notice to quit was served, we went back to the court at the status conference and asked for the account, basically what was owed, to reflect that he hadn't paid in a number of months. And then I also drafted a motion for interim use and occupancy to use at the trial. So what the court can do, basically in equity or in fairness, or the inherent powers of the court, the court can order what's called interim use and occupancy. And the idea is, if the court delays the execution, or if we have to continue the trial to a later date, in some cases it would be unfair for the tenant to be able to live at the property without use and occupancy payments, which is what we essentially call rent once the tenancy has been terminated. It'd be unfair for the tenant to be able to continue using the property without paying for it. And so I created this motion that was basically ready in my file, that if the judge delayed execution, we'll be able to ask for those payments in writing and serve the tenant on the spot. Whether the judge would have allowed us to argue it at that time, or whether it would have been continued, who knows, but it's good to have it ready so we don't have a delay. So January 3rd, we have our summary process trial. We get called, and we were ready at the courthouse at 8:30. We actually didn't get our case called until probably about 10:30 in the morning. So we had about 2 hours of time that we were just waiting for the court to be ready for us. And that's because on this particular day, the Plymouth District Court hears both arraignments, which is basically the process of when somebody's charged with a crime, the state will bring them in, the police will bring them in, the charges are read, and the bail is set in some cases, and in some cases an attorney will be assigned, and a plea will be entered. And so while that's all happening, we're waiting for our summary process trial, which is kind of an interesting view into the criminal justice system. If you haven't sat through the arraignment session, I'd recommend doing it. It's you hear a lot of different cases and some interesting stuff. So we finally get called, and our case is called by the judge, and I start going through my offer of proof. So I submitted 7 exhibits, including the notice to quit, a certified copy of the deed to establish that my client owns the property, a certificate of good standing from the Secretary of State's office to establish that he's the manager of the LLC, some cleared checks to establish what the monthly rental amount was, because remember, we didn't have a written lease agreement. I also provided a copy of the summons and complaint. So basically all the documents were submitted to the court. And then once the evidence had closed and I had asked the tenant some questions, when he moved in, was he served with the notice to quit, what his intentions were, the judge basically stopped us before our final argument and said, in my opinion, I think the parties should go discuss this one more time. To be clear, tenant, what are you asking for? And the tenant said, I need 90 days to vacate. And so the judge kind of made it clear that he was likely to grant that sort of stay. And so I talked to my client for a moment and advised him that we should try and negotiate this matter, because the judge, in a case where the tenant is over a certain age, or if the tenant has a disability, the judge actually has discretion to stay execution in a no-fault eviction for a period of up to 1 year. And so in theory, the judge could have actually allowed that to happen. Now, granted, the judge is probably going to allow the tenant to stay at the allow the tenant to stay at the property only if the tenant is making monthly use and occupancy payments, but the fact remains that we don't want to test what ultimately the judge wants to do here. So what we did is we negotiated with the tenant. The tenant agreed to be out by March 31st. We prepared an agreement for judgment where the execution would issue on April 1st. We had a portion of the unpaid rent treated as a judgment, and then the remainder is use and occupancy that's due on the first month of every month for February and March. So ultimately, this was a great outcome for my client because he's either going to get the apartment back right away without a long stay if the tenant doesn't pay by, we actually agreed on January 6th, 2025. So if the tenant doesn't pay timely, then the landlord can essentially on 3 days notice ask for possession. So that was a great outcome, or he gets paid in full, which is another good outcome. But there were some challenges that I think are worth noting here. So the first one is the statutory time. So you'll see that there was a big waiting period from the date that the tenancy was terminated until that first status conference. We're talking about months and months. So serving the notice quit in August, we didn't get into court for 3 to 4 months. So that's a big problem. And that is because of this court scheduling. It used to be by statute, it would be a certain number of days. Now the court gets to decide when the hearing is. It's just a reality of where we're moving. We used to be able to get hearings a little bit faster. It's not anyone's fault. The court's busier than ever. They're overworked. And as an outshoot of that, we just don't get access to the courts as quickly as we might like. Staying the execution is a big problem that's always looming in the background. So giving the judge discretion to stay execution for a long period of time, that gives the tenant some leverage to say, okay, I want to remain in possession for a considerable amount of time. And a lot of times the landlord has to at least give some credence to the possibility that that's going to be that's going to win the day with the court. And then really what we haven't talked about would be fees and costs. So with the travel time, with all the drafting, with waiting, and that's a big part of all this, we're looking at probably somewhere in the neighborhood of 10 hours of legal time, which is a considerable amount of money. That's probably 3 or 4 months worth of rent. So if we're talking about a unit where essentially to get somebody else, it costs a third or a quarter of a year worth of gross rent, not even including the costs of upkeep, like taxes and insurance, the true cost of an eviction is actually much higher. And let's think about this in a different way. What if the tenant didn't have his brother pay for part of the period that he was in the property and not paying? What if he didn't agree to these use and occupancy payments? What if the judge said in equity it wouldn't be fair for the tenant to have to pay because of his inability to pay, whereas the landlord might be able to absorb some of these costs? We could be talking about a period of 6 months where the landlord isn't being paid and the tenant is able to stay at the property for free. So the outcome for us was good. The judgment was $2,800. We had UNO for $1,250 a month for January, February, and March. Execution issues automatically on April 1st, so we don't have to go back and incur more fees. We can enforce the agreement on 3 days' notice, which is great. We don't have to wait for a long period of time. And then the attorney's fees are payable on enforcement. So if we have to go back, we can ask the judge to essentially tack on whatever my fees are to what the tenant owes the landlord. But for anyone that's been involved in pursuing judgments against individuals, especially people that don't have any money, we often call them judgment proof, that can pose a real problem. A lot of my clients are surprised to learn that just because they have a judgment doesn't mean it's going to get paid. It all depends on whether the tenant or the defendant's going to pay you. So I want to thank you for watching. If you have questions about an eviction, I'd be happy to answer them. I don't focus my practice on evictions because I think that it's just not something that I find very fulfilling. I like helping people, and to be sure, having a property go back to the landlord certainly is helping people. But I like things like buying properties, selling properties. I like estate planning. I like setting up trusts. I like answering questions. I don't necessarily like waiting in court for hearings. And so that's part of the reason why I tend not to focus on this, but it is something I think is interesting, especially for people that are property investors that run this as their business. And I think it's a good thing to understand that Evictions are very expensive, and to get kind of an idea of what the expense would be in these cases, especially with one where it actually went pretty well. I've had evictions where things didn't go so well, or the landlord was a little annoyed that really the best option for them was something called cash for keys, where you essentially turn over the tenant will turn over the property and those metaphorical keys in exchange for a cash payment rather than going through the eviction process. So like I said, if you have questions, please let me know. If you like the video, I'd love a thumbs up and a subscribe. That makes it a lot easier for me to spend the time creating this content. And until I see you next time, I hope you have a great day.